Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's video. On today's video, we're continuing with our ongoing series entitled The QME's Crystal Ball. And in today's video, we're in session number 4 of this new and ongoing series. And before we get into the topic of today's discussion, let's just briefly review some of the topics that we've discussed so far in this series. This series, the philosophy of this series, is all about obtaining truth and accuracy in the qualified medical evaluation itself and in the qualified medical evaluator's report. And truth and accuracy is necessary because all of the parties, whether we be considering the injured worker, whether we be considering the applicant attorney, the defense attorney, perhaps we're considering the claims administrator, and perhaps we're even considering the most overlooked and most forgotten party involved in each of our cases, and that is the employer. If we consider all these parties, the parties are counting on us to provide opinions and conclusions in our report that are truthful, that are accurate, and that are as close as possible to an accurate representation of the examinee's true condition on the date of our evaluation. So truth and accuracy is critical in the qualified medical evaluation report. Well, sometimes this can be difficult because of the very nature of the type of work that we do. It's oftentimes very, very difficult to determine the issues. For example, with an apportionment approximate percentage, it's very, very difficult to, within reasonable medical probability, ascertain an exact percentage of permanent impairment that may be due to the industrial injury, an exact percentage that may be due to other factors. This is very, very difficult to do. In addition to the apportionment determination, we deal with many, many other determinations that, because of the nature of the work that we do, it's difficult to be absolutely certain and absolutely accurate in your determinations on these difficult issues. Well, in these difficult determinations, it would be great if we as qualified medical evaluators had omniscient powers. If we had some sort of a crystal ball that we could look into for guidance to help us arrive at opinions and conclusions that are accurate, that are truthful, that are the perfect representation of the examinee's true condition. And that's the purpose of this program. The purpose of this program is to give you some tools that will help you in these difficult crossroads when it comes time for you to provide an opinion and conclusion on these difficult issues upon which it is very difficult to be absolutely certain. We're providing you tools that you can use at these difficult crossroads to help you arrive at an opinion and conclusion that is the closest you can get to having a crystal ball, the closest you can get to having omniscient power when it comes time to put your signature on an opinion and conclusion in your report. And we spent the first 3 sessions of this program largely talking about how to arrive at opinions and conclusions on the AOE-COE determination, especially in those cases that involved a denied claim. And these denied claims represent a unique species of claim here in the California workers' compensation system, wherein we have many, many, many examinees coming to us with denied claims, wherein the opinion that's required of us as the qualified medical evaluator is an opinion on industrial causation, an opinion either for, FOR, or against industrial injury. And many times these examinees come to us with no proof that an industrial injury actually occurred, and yet we as qualified medical evaluators are called upon to render an opinion that either approves the claim for an injured worker or disproves or disapproves the claim for an employee who otherwise does not qualify for workers' compensation benefits. And it's extremely important that we as qualified medical evaluators provide opinions and conclusions that are accurate, because the last thing we would ever certainly want to do is to provide an opinion against industrial causation for an employee who actually has suffered an industrial injury on the job. That certainly would be unfair and a great disservice to the employee or injured worker. Similarly, with regards to an examinee who is claiming an industrial injury but who has not suffered an actual industrial injury and who does not qualify for workers' compensation benefits, it's extremely important that we provide an accurate opinion to protect the rights and interests of the employer. So accurate opinions and conclusions are critical, and all the parties depend upon us for opinions and conclusions that are accurate. So we spent the first 3 sessions talking about how to be accurate on your AOE and COE determination. In today's discussion, I want to talk to you excuse me. I want to talk to you about some of the other opinions and conclusions in your report that rely in large part on the relevant medical history section of your interview with the examinee and the relevant medical history section within the body of your QME report. Now, it's critical that we obtain an accurate, relevant medical history from the examinee, because the details associated with the past medical history, as that past medical history is relevant to the current claim for industrial injury, is critical in providing our opinions and conclusions on permanent impairment and also on the apportionment of the permanent impairment. And it's important to know that many times examinees will be incentivized to be somewhat vague, to be somewhat forgetful, to be somewhat disacknowledging of any prior relevant medical history that may impact upon the current claim for industrial injury. They simply have no incentive to be accurate historians, and they have every incentive to downplay or to forget prior medical history as relates to injuries and medical treatment to the same or similar body part as that involved with the current claim for industrial injury. They simply have no incentive to recall these important facts, and they have every incentive to neglect to remember these important facts. So we need to know this going into the qualified medical evaluation. And in all fairness to all parties, it's critical that we obtain an accurate, relevant medical history so that we can provide accurate opinions and conclusions both on permanent impairment and also on apportionment of the permanent impairment. And actually, according to law, we as qualified medical evaluators have an opposite incentive to that of the examinee, in that the law provides tremendous incentive for us as qualified medical evaluators to be extremely thorough and extremely investigative in pursuing the examinee's prior relevant medical history. And I'll share with you those incentives as we get into today's discussion. So with no further ado, let's begin today's discussion regarding the relevant medical history in session 4 of our new series entitled The QME's Crystal Ball. Okay, so let's begin. And let's begin by talking about the QME's incentive to pursue an accurate, relevant medical history. Now, in terms of providing opinions and conclusions that are accurate, that are truthful, and that are appropriate for all parties involved in the case, the Division of Workers' Compensation has long recognized the difficulty in actually arriving at this as an achievable goal. And so, the Division of Workers' Compensation has found it within their wisdom, they found it necessary to provide qualified medical evaluators with an incentive to be thorough, with an incentive to be accurate, with an incentive to actually pursue facts and details that are relevant to the opinions and conclusions in the report that will be fair and accurate for all parties involved in the case. So the incentive for the qualified medical evaluator has to do with the complexity factors. So let's review a couple of the complexity factors that provide the qualified medical evaluator with an incentive to pursue an accurate and detailed relevant medical history. And these come from California Code of Regulation 9795, which describes the medical legal fee schedule. And these are the complexity factors that we employ in billing our qualified medical evaluation report. Okay, so let's talk about a couple of these. Under the ML 103, item number 7 has to deal with apportionment. And apportionment, as we know, relates to informing the employer or the claims representative exactly how much of the permanent impairment they are liable for. If we go back to 2004 and the passage of Senate Bill 899, Senate Bill 899 was passed in an attempt to address what were referred to as skyrocketing costs in workers' compensation. And part of the Senate Bill 899 package had to do with changes to apportionment laws that provided that the employer is only liable for the portion of the permanent impairment directly due to the industrial injury. And that's wherein the qualified medical evaluator's apportionment determination becomes critical. So in order to pursue an accurate determination on apportionment, the complexity factors provide us an incentive to pursue an accurate, relevant medical history. So let's read the complexity factor. It deals with addressing the issue of apportionment when the determination of this issue requires the physician to evaluate the claimant's employment by three or more employers. Thus, it's critical to have accurate history relating to the examinee's employment with prior employers, and also when evaluating three or more injuries to the same body system or body region as involved in the current claim for industrial injury, or when evaluating two or more injuries involving two or more body systems or body regions the same as involved in the current claim for industrial injury. So this complexity factor provides incentive for the qualified medical evaluator to pursue injuries with prior employers and to pursue prior injuries to the same body system or the same body region. In providing for this complexity factor, or in providing this as a complexity factor, the Division of Workers' Compensation provides for us as qualified medical evaluators a higher pay scale. It allows us to bill at the highest billing level, the ML 104 billing level, for pursuing what is probably present in most examinees' past medical history, and that is a past medical history of injuries to the same body part or same body region as involved with the current claim for industrial injury. In other words, most examinees are probably a lot like most of all of us in that we've had prior injuries. We've had many prior injuries ranging all the way from childhood through adolescence, through sports camps, through physical fitness pursuits and activities, through activities of daily living and job requirements. We've had prior injuries to various body parts which could overlap with the current claim for industrial injury. And examinees are a lot like you and they're a lot like me in that they do not live in a bubble and they do not live daily, constantly protected 24/7 by the safety gods that protect them from ever accumulating a bump, a scrape, a bruise, a sprain, a strain, a fracture, a concussion. Okay, so examinees have prior medical history of injury to the same body part or same body region. And the Division of Workers' Compensation and legislators who have passed these laws, this is a law, California Code of Regulation 9795 is a law, lawmakers have found it fit to incentivize us as qualified medical evaluators to dig into the prior medical history so that when it becomes time to provide an opinion on the apportionment, that apportionment opinion is accurate. That apportionment opinion is truthful. The apportionment opinion is appropriate. So that the apportionment opinion, when we have all of the relevant facts in order to consider the apportionment approximate percentages, when we have those facts, we can come as close as possible to a determination that's truthful, short of actually having omniscient powers and short of actually having a crystal ball. Here, the Division of Workers' Compensation provides us with their version of a crystal ball by encouraging us to dig into the past medical history and for compensating us handsomely for doing so. Okay? So that's the ML 103-7 complexity factor regarding apportionment. In addition to that, under the ML 104, complexity factor number 2 reads as follows. It says, when the evaluation involves prior multiple injuries to the same body part or parts being evaluated, we get paid at a higher rate for actually taking the necessary time, taking the effort, taking the steps necessary to arrive at accurate opinions and conclusions. The Division of Workers' Compensation incentivizes us and allows us to bill at the highest billing level when we satisfy this as a complexity factor. So the qualified medical evaluator has tremendous incentive to dig into the examinee's relevant medical history in order to provide opinions and conclusions that are accurate for all the parties involved. And doesn't that make sense? The Division of Workers' Compensation rewards us for going the extra mile, incentivizes us, compensates us handsomely for going the extra mile to arrive at opinions and conclusions that once and for all are accurate, that are appropriate, and that are as close as possible to the truth, should we actually have a crystal ball or should we actually have omniscient powers. Okay, so the QME is tremendously incentivized. And let's see now what the law has to say about some of the lines of questioning that we should pursue in order to arrive at accurate opinions and conclusions regarding the apportionment determination. Okay, so let's talk about apportionment in those cases wherein you provide for permanent impairment for your examinee, and let's talk about the necessity of obtaining an accurate and detailed relevant medical history so that you can provide accurate opinions and conclusions on the apportionment approximate percentages. Okay, so let's read here from Labor Codes 4663 and 4664, which are new apportionment laws that were part of the reform package that involved Senate Bill 899 back in 2004. Now, Labor Code 4663 is not new, but it includes changes over prior Labor Code 4663, whereas Labor Code 4664 is new with the passage of Senate Bill 899. So with regards to Labor Code 4663, let's just read a couple of relevant passages. 4663 tells us that now in the new era, since the passage of Senate Bill 899, apportionment of permanent disability shall be based on causation. And the qualified medical evaluator is required to opine and inform the parties as to the various causes of the permanent impairment on the date of the qualified medical evaluation. So when we determine that the examinee has permanent impairment, it's required that we assess as to the various causes, including the industrial injury, of that permanent impairment. Okay? Section B tells us, and this is the law, a physician who prepares a report that addresses the issue of permanent disability due to a claimed industrial injury shall also in that report address the issue of causation of the permanent disability. So in this section of 4663, this is the requirement that we as qualified medical evaluators address apportionment in those cases that involve permanent impairment. Now, addressing apportionment is required by law under this section of 4663. However, addressing apportionment as required under this section of the law does not qualify apportionment as a complexity factor unless the addressment of apportionment involves what we described earlier under the complexity factor as involving employment by 3 or more employers, 3 or more injuries to same body part or body region involved as the current claim for industrial injury, or number 3, 2 or more injuries involving 2 or more body regions, including body regions, same body regions involved in the current claim for industrial injury. So addressing apportionment as required by law is not the same as employing apportionment as a complexity factor. So it's important that when we address apportionment, if the examinee has prior multiple injuries, 3 or more prior injuries, or 2 or more injuries involving 2 or more body regions, it's important that we elaborate on each of those injuries and discuss how each of those injuries contribute, if at all, to the cause of the current claim for permanent impairment or permanent disability. Okay? Thus, again, the importance of an accurate, relevant medical history. And here's sort of the kicker with regards to Labor Code 4663. It tells us that in order for a physician's report to be considered complete on the issue of permanent disability, the report must include an apportionment determination. Again, that does not qualify your apportionment determination as a complexity factor unless it meets the strict requirements contained within the complexity factor. A physician shall make an apportionment determination by finding what approximate percentage of the permanent disability was caused by the direct result of the injury arising out of and occurring in the course of employment. So that's the portion of the impairment due to the injury, comma, and what approximate percentage of the permanent disability was caused by other factors, both before the industrial injury and subsequent to the industrial injury. And here's the kicker. It says, comma, including prior industrial injuries. Isn't that amazing? Isn't it amazing that it does not say including prior automobile injuries? It does not say including prior sports injuries. It does not say including prior slip and fall injuries. It does not say including prior birth trauma injuries. It's specific that we investigate the examinee's prior history of prior industrial injuries, and this section of Labor Code 4663 allows for apportionment to prior industrial injuries. Therefore, let me ask you, is the qualified medical evaluator incentivized to dig regarding a history of prior industrial injuries with the examinee? The qualified medical evaluator is indeed richly incentivized to be thorough in pursuing a history of prior industrial injuries, so that when it comes time to make an apportionment determination, that apportionment determination is fair to all parties, that it's accurate for all parties, and so that it's appropriate to the actual situation as that actual situation factually presents itself. So we're tremendously incentivized, and we're going to discuss how to pursue questioning and interviewing techniques to discover and uncover a history of prior industrial injuries. Okay? So that's Labor Code 4663. Let's see what Labor Code 4664 has to say, and if 4664 has also any other reference to prior industrial injuries. Okay, so now Labor Code 4664 takes the theme from Labor Code 4663 regarding prior industrial injuries and expands on that theme and increases the demand and increases the obligation on us as qualified medical evaluators to obtain copious and thorough details regarding prior industrial injuries. The Labor Code 4664 reiterates under Section A that the employer shall only be liable for the percentage of permanent disability directly caused by the injury that arose out of and occurred in the course of the employment. And doesn't that make sense? Doesn't that make sense that the employer should only be responsible for what they're responsible for? Well, in order to determine what the employer is responsible for and what portion of the impairment the employer is not responsible for, it's incumbent on us as qualified medical evaluators to dig into the examinee's relevant and prior medical history, especially as relates to prior industrial injuries. And that point is emphasized here in Section B by telling us that if the applicant has received a prior award of permanent disability at any time in the past, even prior to the passage of Senate Bill 899 in 2004, it shall be conclusively presumed that the prior permanent disability exists and persists at the time of any subsequent industrial injury, including the time of the current claim for industrial injury with the current employer. Tells us that this presumption is a presumption affecting the burden of proof. And this is new. This section of Labor Code this section 4664 is new. It used to not be that if an examinee received a prior award of permanent disability, it used to not be presumed that that permanent disability existed and persisted into the future forever. This is new. The new law tells us that if the examinee had a prior award of permanent disability, the examinee currently has the same permanent disability that they had when they were awarded that permanent disability. It tells us that the examinee, if they had a prior award of permanent disability, then that disability existed even at the time of the current industrial injury. And this is where thorough investigation into the relevant medical history is critical. So when it tells us here, that the prior permanent disability exists at the time of any subsequent industrial injury, what does that mean? What does that mean? What does it mean that the prior permanent disability exists? What does that mean? Well, it means that if the examinee had a prior permanent disability associated with pain, then the pain exists and persists at the time of the subsequent industrial injury, and it exists and persists into perpetuity forever, including the time at which this examinee comes to see you for the qualified medical evaluation. So if the examinee has a prior award of permanent disability, don't be surprised. Don't be surprised when the examinee comes to you and reports that they have pain. The law tells us that they already had pain. They already had pain, and they will forever have pain into the future forever, because any prior permanent disability exists and persists at the time of any subsequent industrial injury. And this is new. It used to be that an examinee could receive an award for a permanent disability, and then after they cashed the check for that permanent disability award, after that they could claim a medical rehabilitation. And you've probably had examinees that tell you, yeah, I had a prior award of permanent disability, but after that I lost 40 pounds, I started going to the gym, I cleaned up my diet and did regular yoga stretches, and I rehabilitated myself, and therefore when I had a subsequent industrial injury, I was perfect. I was perfect. There was nothing wrong with me. I was medically rehabilitated. And in those cases, the examinee could have a subsequent industrial injury could be rated for permanent impairment or permanent disability as a result of the subsequent industrial injury and could get a brand new pocket, a brand new award, a fresh pot of money for their new, never before had permanent disability. And the current law, 2004, changed and it said no double dipping. If you had a prior award of permanent disability, that prior award of permanent disability exists at the time of the subsequent injury. It exists and persists forever, including the pain. What else about it exists at the time of a subsequent industrial injury? How about any objective findings that they had at the time that the prior disability award was rated by a qualified medical evaluator? If they had reductions of range of motion, if they had positive findings for radiculopathy, if they had orthopedic indicators at the time, those positive physical exam objective findings persist and exist at the time of any subsequent industrial injury. And in fact, this passage from Labor Code 4663 tells us that at the time of the subsequent industrial injury, the examinee was already damaged goods. The examinee already had a bad back. The examinee already had bad knees, already had bad shoulders. At the time of the subsequent industrial injury, the examinee was in rough shape. So therefore, we don't be surprised when the examinee comes to us regarding the subsequent industrial injury and tells us that they're in bad shape. So the law allows and requires apportionment to prior permanent disability awards, and thus the necessity for digging into deep details regarding the relevant medical history involving the same body part as involved with the current industrial injury, including the level of pain, including the limitations to activities of daily living, including any findings that they had on diagnostic studies at the time of the prior industrial injury. Dig for details. It's required by law, and we're richly incentivized for doing so. So let's talk about a couple of ways that we as qualified medical evaluators can elucidate these details in the face-to-face evaluation with our examinee. Okay, so let's talk about some things that you can do in order to elucidate a relevant prior medical history with the examinee. And we're going to talk about things that you can do both prior to the face-to-face evaluation with the examinee, and then some things that you can do at the face-to-face evaluation with the examinee. Now, prior to the face-to-face evaluation with the examinee, you may be reviewing the medical records, and the medical records may give reference to some prior history of medical treatment and or injury to the same body part as involved in the current claim for industrial injury. Now, this does not happen all the time. Many times the medical records that we receive are related only to the current claim for industrial injury, and so they represent a very small portion of the examinee's entire scope of lifetime medical treatment. But even in those cases, sometimes you will find a reference to earlier medical records, or a reference to earlier medical treatment, or a reference to an earlier injury to the same body part or body region. And let me just give you an example. I recently had an evaluation where I received medical records, including medical records for the industrial injury, and also the examinee's prior private personal medical records from his primary care physician. So I got records from the primary treating physician related to the industrial injury, and also the primary care physician on a personal basis related to the examinee's private health care insurance. Well, in the medical records from the primary care physician, on the date of first visit with the primary care physician, the medical records stated basically that the examinee was here to establish a relationship with the new primary care physician, as the examinee was transferring his care from Kaiser now to the new primary care physician. He did this because his job changed. His private health care insurance changed from Kaiser to a new provider, and he was now transferring to the new provider as his primary care physician. And the primary care physician took a history and elucidated some of the significant complaints from the examinee's medical history, and it included a prior complaint of back pain for which the new primary care physician related that the examinee had prior treated at Kaiser for symptoms related to back pain. So this suggested to me that the examinee's history of back pain, and this was a case that involved a lower back injury, his history of treatment for back pain went back even prior to his job change that involved new private healthcare insurance. So that was a clue that I would be required to investigate back pain issues dated back many years involving treatment at Kaiser and possibly even treatment that antedated his treatment at Kaiser. So medical records, while they may not directly reference prior history with the same body part, they will include references or inferences or some other notation that will lead you to believe that perhaps a prior medical history exists. Also, diagnostic studies may give you a clue. I think it was the same case that I was just telling you, that when the examinee went to the new primary care physician obtained x-ray studies at a local imaging facility that had prior obtained similar diagnostic studies of the examinee, although under the referral of a different referrer. So in this case, when the examinee went in for lumbar spine x-rays, I think it was, the imaging facility made reference to comparison studies obtained like 5 years earlier. And so the medical radiologist stated in the body of his report of findings, comparison is made to prior 2015, I think it was, lumbar spine x-rays, and that indicated to me that indeed the examinee had received prior medical treatment and prior diagnostic workup for similar body part as involved with the current claim for industrial injury, and that led to my pursuit of a series of questions in the face-to-face evaluation regarding that past medical history. Sometimes, and some doctors find it important and helpful to do background searches on their examinees for whatever information that background search may reveal. And I'll give you an example of how a background search recently shed some insight into one of my examinees. I had an examinee who was claiming an industrial injury, and the industrial injury was kind of vague. Her treatment had gone on for a lengthy period of time, and she was still complaining of ongoing symptoms and activity limitations. And the claim seemed to be a bit unusual in that the mechanism of injury was minimal, and the disability seemed a bit protracted, especially considering that medical treatment seemed to be appropriate and adequate. And anyway, the examinee presented to the qualified medical evaluation accompanied by her husband. And the husband was very interested to be involved in the evaluation. And when I informed the husband that we would be approximately 2 to 3 hours, the husband indicated to me that he intended to be involved with the evaluation. I informed him that the room that we had would not accommodate a third person, and that I was well qualified to conduct the evaluation and that I knew what I was doing. And he informed me that he intended and insisted to see that his wife receive the full benefit of workers' compensation benefits, and it was his intention to ensure that she indeed received the full spectrum of those benefits. Well, I did succeed in assuring the husband that it would be okay for him to perhaps go shopping or do some errands and come back, and we would be completed with the evaluation in 2 to 3 hours. Well, during the evaluation, during the social history, I learned from the examinee that the husband was off work on a workers' compensation disability, and he was recently retired due to his inability to go back to the pre-injury occupation at which he was injured not once, not twice, but 3 times. And he was now on work. He was now retired and no longer engaged in the pre-injury occupation. Well, I succeeded in obtaining the name of the husband, and when I got back to my office, I did a case information search on the EAMS website, and I'll share with you exactly how to do that in just a minute. And I learned through an EAMS case information search that the husband had had 3 separate and distinct industrial injuries with the same employer, for which he had received 3 permanent disability awards, all with the same employer, and was now quote-unquote disabled at age 56 and no longer gainfully working. Well, I concluded from the entirety of that interaction that the husband was quite intent on obtaining a similar outcome for his wife, although his wife was only partially committed to that process. And so this is an example as to how background search on either the examinee or perhaps one of the examinee's family members can provide you a great deal of information about the circumstances involved with the examinee's claim for industrial injury. Okay? And sometimes your background search could involve using the EAMS case information search for a history of prior industrial injuries. And so let me show you how to do just that. Okay, so with regards to the EAMS case information search, I recommend that you do an EAMS search on each and every examinee, because many times one or more of the parties may not have an incentive to provide you with information regarding an examinee's prior history of industrial injuries. And so without that information, there's no way that you can adequately and accurately opine on the important opinions and conclusions within the body of your report. So many times it's incumbent upon yourself to do the necessary research and obtain this information on your own. And the EAMS case information search, that information is all public information. So let's read from the web page as the web page opens up when you go to the case search. And here I've provided the website for you. And it opens up to the page where it tells us that the information on workers' compensation adjudication cases provided through this search page is public information. This is public information. In other words, this is not confidential. Anyone can obtain this information, and that anyone includes you as the qualified medical evaluator. There's nothing subversive or devious or suspicious about doing a case information search on each of your examinees. It tells us that the search feature provides access to information that helps move cases through the workers' compensation court system efficiently. Each person who requests information through the search function is responsible for ensuring the information is not used for purposes other than those allowed by law. And it requires that if you're going to access public information, that you identify yourself, you state the reason for making the request, which in the case of us as qualified medical evaluators is simply for case information. Case information. I think that comes in the drop-down menu. You simply click the option case information, and that you not disclose the information to any person who is not entitled to it. It tells us that the residence addresses and social security numbers, those are confidential and they're not disclosed by the DWC, that there are no documents available through the search function, and that even prospective employers may use this information prior to deciding to employ any particular person who may be interested in new employment. So The Eames case information search is public information, and it allows you to determine if the examinee has had prior industrial injuries. If those prior industrial injuries have involved same or similar body parts, the body parts are all listed in relation to each separate claim for industrial injury. And it also gives information as to the disposition of the claim, whether the claim settled by way of compromise and release, or whether it's settled by way of stipulated award, or whether the case is still ongoing. So the Eames case information search can provide you as the qualified medical evaluator with information that you can then pursue in your face-to-face interview with the examinee. Okay, so those are some of the things that you can do prior to the face-to-face evaluation to ascertain the possibility that the examinee may have prior industrial injuries or prior non-industrial injuries to the same or similar body part as that involved with the current claim for industrial injury. Now at the face-to-face evaluation, you're going to go through a series of questioning with the examinee to assess prior industrial and prior non-industrial injuries to same similar body part and subsequent industrial and non-industrial injuries to the same or similar body part. So beginning first with prior industrial injuries, this is some information that you may have already ascertained through review of the examinee's medical records and or a Eames case information search. So you should already have reference to these industrial injuries. And don't be surprised if the examinee fails to remember any prior industrial injuries. If they do fail to remember prior industrial injuries, then you can gently remind them that perhaps there was a prior industrial injury in 1998, and you can reference the body parts involved and perhaps the employer involved. And of course, this will intrigue the examinee that you know this type of information. And this will encourage the examinee to search their recollection for details regarding these industrial injuries. So make sure to elucidate all of the industrial injuries that you can through both of your own due diligence in advance of the face-to-face evaluation and encouraging the examinee to recollect any prior industrial injuries that they may remember that may not have made it to the Eames case information search. All of those are relevant, and all of those would go into the prior industrial injuries section. This is under the relevant medical history section of your report. Then you're going to pursue at great length, like a dog on a bone, any prior non-industrial injuries to same similar body part. And again, don't be surprised if the examinee is a vague historian regarding prior non-industrial injuries. And don't be surprised if the examinee downplays any prior injuries to the same body parts. And just it bears repeating and it bears remembering that all of us have suffered injuries at various points in our life. And unless examinees are living on a planet without gravity, and unless they are protected by the safety gods and walking around in a bubble for the entirety of their life, they will certainly have had their share of non-industrial injuries throughout their lives. So pursue prior non-industrial injuries, perhaps taking the examinee as far back as grade school, maybe as far as middle school, finding out whether or not they played on any recreational or intramural sports teams and whether or not they suffered an injury there, and really exhaust the examinee's memory for prior injury to the same similar body part. Okay, so that is related to injuries that may have occurred prior to the current industrial injury. And then you're going to go through the same line of questioning to investigate injury to the same or similar body part subsequent to the current claim for industrial injury. So at this point in time, the examinee may be working for a new employer, and you'll be concerned as to whether or not the job place activities with the new employer could serve as a source of ongoing and cumulative trauma that contributes to the examinee's current symptoms and activities of limitations. So you'll pursue any subsequent either specific or cumulative trauma injuries, either with a new employer or subsequent injuries perhaps as a self-employed person. So you're going to want to pursue 100 different questions here regarding the incidences and events subsequent to the claim for industrial injury. And then also you're going to pursue subsequent non-industrial injuries after the date of the current industrial injury, pursuing questions about ongoing sporting activities, home duties, whether or not the examinee has been involved in any auto accidents. And if you've been doing this for any length of time like I have, it's not you'll agree that it's not uncommon to have examinees who have had an industrial injury and have then had a subsequent auto accident injury that compounds and confounds the situation. I recently had an examinee who had a cumulative trauma industrial injury and then was variably off work on total temporary disability for a period of like 18 months. And during that 18 months, he had a subsequent auto accident injury wherein he was rear-ended. And the medical records indicated that he received emergency room treatment the same day and a couple of follow-up visits for aggravation of his back pain, of his pre-existing back pain, of his industrially related lower back pain. And upon close questioning, of course, he first was unable to recollect the auto accident injury. But then when I reviewed with him the medical records associated with an ER visit and a couple of follow-up visits, he, of course, downplayed that auto accident injury, even though he admitted that he received settlement compensation for that injury. And he was, like most examinees, he was incentivized to be a vague or poor historian regarding the auto accident, but this was something that was captured in the medical records, and this was something that contributed to the final opinions and conclusions in the apportionment section of my report. And then for those examinees who are vague historians or who seem to have some lapse of memory with regards to prior industrial and non-industrial injuries, you can ask them the catch-all questions such as, have you ever had injury, any other injury, to the same or similar body part that's now involved in this current claim for industrial injury? And for those examinees who have some memory lapse with regards to your other lines of questioning, this may be the type of question that can jog their memory and will prompt them to disclose details regarding prior injury to the same or similar body parts. And then finally, at the face-to-face evaluation, in concluding your interviewing techniques regarding the relevant medical history, it's important to remember that examinees communicate to us both verbally and non-verbally. And so after we exhaust the examinee's memory verbally regarding prior injury and or medical treatment to the same or similar body part, we then assess the examinee non-verbally, and we look for physical findings that could indicate a prior history of injury, such as the presence of scars, such as the presence of a deformity of the same or similar body part, or a body part that could impact through compensable consequence the involved body part. Physical exam finding that we can observe with our eyes simply in the face-to-face evaluation would include atrophy, would include the presence of tremors, and certainly when the examinee is ambulating to and from the examination room, a gait disturbance could signal some prior industrial injury that overlaps, the current claim for industrial injury that could be relevant in your final opinions and conclusions. So be aware also of both the nonverbal findings that you can elucidate simply by observing the examinee. So doctors, I hope this helps you. Isn't that a fascinating discussion regarding the competing and contrasting incentives of the examinee compared with the incentives of the qualified medical evaluator? So the legislators and the law, and also the Division of Workers' Compensation, and all the parties involved in each and every one of our cases is concerned that we provide opinions and conclusions that are accurate, that are truthful, and that are appropriate to the facts of the particular case that we're evaluating. Well, this is sometimes a difficult task because in terms of a prior medical history to the same or similar body part, examinees may be incentivized to fail to disclose prior injuries to the same or similar body part when that disclosure could impact their current claim for industrial injury and benefits under the workers' compensation system. Examinees are incentivized to be poor historians in this regard, and so as qualified medical evaluators, we need to be aware of this in going into the evaluation. On the other hand, our obligation as required by law under Labor Code 4663 and 4664 is to provide accurate opinions and conclusions regarding apportionment of the permanent impairment. And in addition to apportionment, we're required to provide accurate opinions and conclusions regarding other issues that can be impacted by the examinee's prior medical history. For example, opinions regarding AOE-COE could be impacted by the examinee's prior medical history, and you may find that once you have fully elucidated the examinee's prior and relevant medical history, you may opine that their current complaint of symptoms for which they're alleging an industrial injury, you may opine that those symptoms are not in any way related to a new industrial injury, but that those symptoms were simply pre-existing symptoms unrelated to any industrial injury. So it's not only the apportionment determination, but it's other determinations in our report that rest and are based upon accurate details related to the examinee's prior medical history. And the Division of Workers' Compensation greatly incentivizes us as qualified medical evaluators to pursue the examinee's accurate and true medical history as relates to the current claim for industrial injury. And in this discussion, I've given you several techniques and several procedures to use to help you develop clues to a relevant medical history as that medical history may impact the current claim for industrial injury. So doctors, I hope this helps you, and I hope you'll take these suggestions to heart and employ them in your very next evaluation with your injured worker. Now, in our next session, we're going to shift gears a little bit, and we're going to talk about how to obtain true and accurate findings in the physical examination by investigating the true nature of positive, objective physical exam findings. So for now, this is Dr. Perry Carpenter. I want to thank you for joining me on today's discussion. I look forward to being with you on future discussions as well. And for now, I'm wishing you best of success in your career as a qualified medical evaluator.